Week 15 is upon us, the last week. I hope you've enjoyed the course and gotten something from it. We have one chapter left, which covers risk management and safety for property managers. Primarily, this consists of making sure that your premises are safe, protect your tenants from possible crime, having an emergency plan in place, making sure your units are well maintained so that someone cannot claim later that something that you did or didn't do caused them harm. A few years ago here in Boise, we had an incident with a gas-powered hot water heater that was malfunctioning, and a young man and his girlfriend sleeping in the apartment became very ill and overcome with carbon monoxide poisoning, and the young man died as a result. There were no working carbon monoxide detectors in the unit, and this was just tragic. I actually happen to know the property manager who was involved in that, and he's obviously very just sick about it. But you know, things like that happen, and so it's just a good idea to keep in mind that keeping your units well maintained and having an emergency plan in place. What happens if there's a flood or if there's a fire? What happens if your office is damaged or your computer system is hacked? What happens if there's a unit a tenant causes something to catch on fire, and perhaps you have 3 or 4 tenants who are displaced from the fire? These things happen from time to time, and while we can't prevent everything, we can be prepared to deal with it if it comes. And so this chapter talks about risk management. I also want to talk about evictions and give you the Reader's Digest condensed version of how you evict someone, because I know this is a very popular topic. Many times I will get questions from the students in the course because they have their own personal situations involving a landlord or a tenant that they have questions about. I worked in a law office for many years as a paralegal, and I can certainly give you my medical opinion about your situation if you have a question. Please know I am not an attorney, have never been an attorney, and I have some superior knowledge about the process, but I don't want you to rely on anything I might say as gospel. If you do need the help of an attorney, it would be a good idea for you to consult one. One of the most common questions I would get is, I have this roommate or I have this significant other who won't leave. I've asked him or her to leave. They won't get out. What can I do to get them out? The answer is you have to follow the same steps to evict somebody, whether it's a roommate, a child, a parent, a significant other, a former significant other, whoever it is, a tenant in a unit that you own or manage. There is a process that you must follow. There are 2 different processes for evicting someone. And mind you, we are not talking about agricultural property that's more than 5 acres, and we're not talking about mobile homes parked on a mobile home space. If we're talking about a mobile home that is space rent in a park, that is a different section of the law, and I don't know that any of you are going to run into that today, so we're not going to talk about it because there are special rules for that. Also, for agricultural property of over 5 acres, there are some different rules for that, and we're not going to get into that because that's not commonly what you'll encounter. Just know that it's different. But for most residential property, including if you're renting a mobile home, an apartment, a house, or if you're a roommate or have a roommate, the same rules all apply. I would say one of the most common problems is that people don't pay their rent. Now, sometimes the person may never have paid rent because you never asked them to. So that's fine. You don't have to have a written lease to collect rent from somebody. It's a good idea to have something in writing, as we have discussed previously, if you expect to collect rent. And it makes life a lot easier for you if there's a problem later. But if someone's not paying rent and you've asked them to, then you can give them what's called a 3-day notice to pay rent or quit. There are many forms either on the court website, or some attorneys' offices have forms on their website for clients to use. I will put some links on the module for your use if you ever do need any of these forms. But the 3-day notice is when someone hasn't paid the rent. Now, if you've never asked them to pay the rent, then you have to give them a different notice first and tell them that effective this date, you have to start paying rent and here's the amount. And typically that is 15 to 30 days in advance that you have to give them the opportunity to start paying rent. Then if they don't pay the rent, you can give them the 3-day notice to pay rent or quit. If the person is paying the rent, but you just don't want them there anymore, or their lease is up and they haven't left and you've asked them to leave, or maybe you haven't asked them to leave in writing, then you need to give them a 30-day notice of termination of tenancy. This gives the person 1 month to leave without penalty, and you must give this notice in writing. Again, there's a form available on many websites. People sometimes ask me, well, I told them in a text, or I told them in an email, or I just told them verbally. That's really not quite good enough. You might get away with it in court if the other person doesn't show up at the hearing, but I really recommend that, as we have said in the past, if it's not in writing, it didn't happen. And typically you will want to attach that notice to the complaint if you have to file one in court to evict the person. You can serve these notices yourself. You need to keep a record of how it was served and when. You don't have to personally hand it to the person. If they're not home, you can tape it to the door, but then you have to mail them a copy of it. And just keep a copy for yourself and note how you served it. Let's assume that you've done everything that you can, you've given them the proper notices, and they don't get out. This happens frequently. In Idaho, every eviction is a lawsuit. Now, you cannot just lock the door, change the locks, and kick the person out. If you call the sheriff and ask the sheriff to kick them out, the sheriff will not do it until you have gone through the court process. So please don't do, the self-help eviction where, I waited till they were at work and I put their stuff out in the driveway and changed the locks, because that will get you in trouble with the law. You have to give everyone the proper notice and the opportunity to take care of whatever it is and get out on their own before you go to court with them. But assuming you've given all the proper notices, then you can file a complaint in court, and you will also have a summons. There are forms on the court website, or sometimes you might want to hire an attorney, especially if you're an LLC or a corporation. You will have to hire an attorney because you're not allowed to represent an LLC unless you are an attorney in court. If you're just an individual, then you can go on your own and file the paperwork with the court. You will give it to the sheriff to serve, or a process server. It doesn't have to be the sheriff, any process server, but it can't be you that serves the court paperwork. They'll personally deliver it to someone at the house, and if it's for non-payment of rent, the court will set it for a hearing within 12 days and just summon the person to appear in court before the judge. If it's for overstaying the lease or some violation of rules of the lease or some other notification that you've given the person that they have to vacate, then the person gets 21 days to answer the complaint because it's just a regular lawsuit. So that process takes a little longer. The non-payment of rent can be done on an expedited basis. Now, there's one other way you can evict somebody fast, and that's if they're using drugs on the premises, or there's a reasonable suspicion that they're using or trafficking in drugs on the premises. It doesn't have to be the tenant. It can be one of his guests or friends. We've had several instances over here in Boise where there have been arrests made at a property, and it wasn't even the tenant, but it was somebody else who was arrested who happened to be at the property for possession of drugs. And then you are allowed to evict that person and go directly to court, and you don't have to even give them a notice. You can just file the paperwork in court and get them out immediately. Unfortunately, that does happen often enough. And the nice thing is, if your tenant or the person that you want to evict has actually been arrested and is in jail, it's very easy to serve them there because we know where they are. And you can serve paperwork in jail, so that's an interesting fact. Now, once the person goes to court, then if they don't show up, then the court will give you a judgment and a writ of restitution. And the same thing if they don't answer the complaint in a traditional eviction. If they don't answer, you can file for a default judgment. When you get a default judgment, you'll get an award of your attorney's fees if you paid any, and you will get what's called a writ of restitution. That is the paper that you take to the sheriff, and then and only then will the sheriff evict them and get them out for you if they haven't already left. Typically what the sheriff will do is go the day that he serves the paperwork, post it on the door, and check back the next day to see if they've gotten out. Oftentimes, especially over here in Boise, I'm acquainted with the sheriff's deputies who do this work, and they'll call me up and say, okay, the person's almost out, so what do you want me to do? And I'll say, okay, give them a couple more hours. Or sometimes the sheriff will stand there and say, start packing, you need to get out. I told you yesterday you need to get out. And he'll stand there and watch them pack up their car and leave. And so it's, it's not pleasant, but that's the process. Many times people ask me, they owe me all this rent, and they think that they're going to get all the back rent as a judgment, and they're probably not. Because if in an expedited eviction, all you're going to get is your attorney's fees. Now, you can ask for back rent if you file a standard eviction. There's a lot of detail here, and I don't really want to get down in the weeds too much, because if you ever run into this, you're not going to be able to do it probably the first time on your own. You're probably going to have to get some legal counsel or do some studying up on it, because there are a lot of nuances. Everything is fact specific. The most important thing I want you to get out of this discussion is that every eviction in Idaho involves a lawsuit with court, and you cannot just lock someone out or tell them to leave and expect them to expect that to hold up in court. Those are the things that I really want you to understand out of this. It's unfortunately a fact of life. I have had property managers who've called me and said, I've been doing this for 20 years and I've never had to evict someone until today, which is a miracle. And then I have property managers who are sort of what we call the frequent flyers, because they would have 2 or 3 or 4 every month. So it just kind of runs the gamut. But you want to make sure your properties are well maintained, and you want to keep an eye on things and do an inspection periodically. I'm going to post some pictures of some actual properties that our clients sent to us that they encountered either when people moved out, or one involved a lady who was a hoarder, and they had to evict her. There was obviously some mental illness issues there, and it was very, very, very sad. The entire floor to ceiling of her apartment was packed with stuff, and she had a vaulted ceiling. It's and if you don't check on the places periodically, you don't realize it's getting that bad. So it's a good idea to do inspections, give a 24-hour notice that you're going to come in and inspect or do maintenance work. The Enricos talked about that a little bit in their video a few weeks ago, and it just helps you keep the risk down of pest infestations, fire. If you accept assisted housing assistance such as Section 8 vouchers or SECA or something like that, then they will come around and inspect the properties too and make sure they're in good repair, and you don't want to find out when the fellow comes from HUD to do the inspection that you've got a problem, so you want to stay on top of it. Now, a word about the final exam. It is open book. Please do not wait until the day it's due to start it. There are a number of multiple choice questions. There are a couple of short answer essay questions, like case studies that we've done in class, and there are several calculation questions. You'll want to be able to refer to your textbook, take your time, start early. It'll be available to you the same day this module becomes available. So you'll have a full 2 weeks to work on it, almost, I think like 11 or 12 days. Please start it early and look up the answers and make sure you get them right. Make sure you understand how to find something. That's the most important thing for me. Not that you have memorized a lot of information from this course, but that you know how to find it if you need it. Thank you so much for your attention. I hope you have a great week.